Welcome to Case by Case. This is a podcast brought to you by Zyla Floyd Zadkovich. Today, in the absence of Luke Zadkovich, but you still have Calum Chain, and we have Leo Rees-Murphy deputizing for Luke, a fellow Australian, one in, one out. Welcome back on the podcast, Leo.
Great to be here, Calum. Great to be back.
We were just discussing that last time you were on, you were looking at an Australian case, so it's good that we've got you now on a English law case, and not just any English law case, a Supreme Court decision, a very recent Supreme Court decision.
Absolutely, and a super interesting one as well, clarifying a particularly controversial area of law, so it'll be an interesting discussion ahead.
Before we get into it, it does clarify this area of law, provides a great amount of clarity in this area of law. It sort of upholds the key case around this point of law while really digging into it and kind of having a bit of a go at how that decision was made. It says you kind of got there in the end somehow, but the decision was completely different to the way that we should have gone about it.
Absolutely. And for our listeners, it's Philipp and Barclays Bank, UK PLC. The citation is 2023 USK 25, a decision of the Supreme Court on appeal from Court of Appeal.
And this is one which has done the kind of unusual, or perhaps unusual, I've not seen data on this, but the perhaps unusual process through the courts where the decision from the initial trial judge was overturned in the Court of Appeal, and the Court of Appeal was then overturned in the Supreme Court. So whenever that happens, you know that it's a reasonably narrow point. Although in this judgment, or in the judgment of the Supreme Court, not that narrow, because Lord Leggett, who gave the leading judgment, was agreed with by Lord Reid, Lord Hodge, Lord Sales, and Lord Hamblin. So unanimity at Supreme Court level, but unanimous in overturning the Court of Appeal, which in turn had overturned the trial judge.
Absolutely. And it may be helpful just to give a factual overview from the outset. The case begins with a Mr. Dr. Philipp, who was contacted in February of 2018 by a fraudster who claimed to be working for the Financial Conduct Authority in conjunction with the National Crime Agency. Now, the case concerns APP fraud, which is authorized push payment fraud. And the way it works is generally a fraudster tricks the victim into voluntarily transferring a sum to the fraudster by posing to be a legitimate payee. Now, in this case, they told Dr. Philipp that his savings in an investment firm called Tilney were being investigated for fraud, and that for the safety of his account, he had to move it to a third-party account that would be safe from this alleged fraud. Now, a feature that was noted by Lord Leggett as being particularly striking was that Dr. Philipp was even persuaded not to cooperate with the police when Dr. Philipp and his wife received a visit from a police officer warning them that the police force believed a fraud was being perpetrated upon them. The sophistication of the fraud was also evident in the fact that they were able to spoof the number displayed on his telephone to actually appear as if it was coming from the NCA, and on another occasion actually appear as if it was coming from the police force. So there was a fairly high level of sophistication in this particular fraud.
Funnily enough, I've seen that fraud play out, not in anything like the detail or duration that happened to Dr. and Mrs. Philipp, but I was once on the end of a scam call, and the number they were calling from was the Court of Appeal Civil Division Listings Office, which was a number that was saved in my phone. So my phone rang and it came up with the contact Court of Appeal Listings, and I answered the phone, and it was somebody obviously pretending that I had some kind of tax liability or something. But there is this ability, kind of concerning ability, that fraudsters have to basically throw a phone number, which is not the one they're actually calling from. And that, obviously was one of the many reasons why Dr. and Mrs. Phillips kind of fell for this scam. And it's quite a sad story, really. They ended up losing £700,000. That was the bulk of their life savings. It's really not a very happy story. And I think the key the key factual point in all of this is that, yes, they were defrauded. Yes, looking back, they would definitely not have made the payments from Barclays. Yes, the payments were to a fraudster, but at no point were they out of control. And I say that kind of loosely because obviously they were out of control in the sense that they were in the hands of the fraudster. But they were the ones who were making all the payments. They were the ones who were insisting on the payments being made, despite issues being raised by Barclays, despite visits from the police. They were the ones who were insistent that this money must be transferred ultimately into the hands of the fraudster, and that's significant in the context of the claim. I suppose their key contention is that the bank, so Mrs. Phillips, her claim was that the bank was responsible for the loss of the £700,000 because she argued the bank owed her a duty under its contract with her, or otherwise at common law, not to carry out her payment instructions if the bank had reasonable grounds for believing that she was being defrauded. That is the legal point that gets us to the Supreme Court effectively, because it all stems back to this concept of what duty does a bank owe its customers, where there are question marks over the nature of a instruction given from the customer to the bank.
Yeah, that's exactly right. And what was, I think, particularly interesting in this case was not only did Dr. Phillips and his wife actually authorize personally the payments by attending at the branch and then asking for the payments to be made, but further, Barclays actually called them to confirm whether they wanted to make these payments on each occasion.
Yeah,
they expressly confirmed. So there can be no doubt that the payments were authorized by Dr. Phillips and his wife, Mrs. Phillips.
Kind of getting ahead of ourselves a little bit, but this is the key difference between a lot of the banking fraud decisions that you see and a lot of the banking fraud decisions that are referred to in this judgment, is that often you have somebody doing something on behalf of somebody else. So somebody comes along and says, I'm entitled to instruct this bank to make this payment. The bank makes the payment, and then the person whose account has been drained comes along and says, well, no, that person never had the authority to make that payment on my behalf or to give you instructions to make that payment. Whereas here we have a kind of, I suppose, an attempt to extend the law on that duty to a situation where the person in question was the one giving the instructions to the bank. The charge against the bank is, you didn't do enough to make sure that I wasn't being defrauded here in making that payment. I suppose the reason, the way we get here procedurally is it's an attempt by the bank to dismiss the claim on a summary basis. They're saying, as a matter of law, this claim must fail because we don't owe any duty of the sort. Of the sort. This is a kind of series of appeals from that initial summary judgment hearing.
Absolutely, which then leads us to the main line of authority that was considered in this case, which was a line of authority of the Quince-of-Bel decision and authorities that followed. And I guess to give a brief overview of the Quince-of-Bel decision, it was decided reported in 1992, but it was actually decided in 1988. So initially when the decision came out, it didn't receive a prominence, and it wasn't a trigger to a massive wave of litigation. Came out quietly, but then came on to, as Justice Leggett says, have quite a prominent afterlife.
This is an interesting case where or at least at Supreme Court level, the Quince-of-Bel case, or the case from which this Quince-of-Bel duty originally came from, hadn't received the kind of detailed scrutiny which it now receives. It's interesting to see the way that the Supreme Court looks at the Quince-of-Bel case. Effectively, this judgment is a really good starting point, maybe even goes further than a starting point, for any questions around the Quince-of-Bel duty, because it looks in so much detail at all the different cases that have, Quince-of-Bel itself, but also what preceded it and what followed it.
I think, and that's the very key point, was that the decision of Quince-of-Bel, which decided, as Calum said a moment ago, and just to repeat it for our listeners, that the courts need to strike a fair balance and say that a banker must refrain from executing an order from the customer for as long as the banker has put on an inquiry, which means that they have reasonable grounds for believing that the order is an attempt to misappropriate the funds of the customer of the bank. And what was particularly interesting about the way Justice Leggett reasoned that decision was he actually started reasoning it from policy considerations. So he found that there was, on one hand, a duty, which was the bank's mandate, that the terms of the mandate given to the customer was that it had to comply with the customer's lawful instructions. But on the other hand, there was this competing duty, which was a duty to exercise reasonable care and skill in executing that mandate of the customer. And so in the face of these two conflicting duties, the Justice Stern, His Honour Justice Stern, resiled by looking at and weighing up policy considerations to reach a resolution.
Exactly, and I think it's a really important point, these conflicting obligations of a bank, right? Because I suppose we kind of assume that the bank is always acting in a good way, right? If you don't have a strict set of rules that the bank is required to follow in its performance of its job as your bank, you're inviting a different problem, right? If you need it to be clear to the bank that if you ask them to make a payment on your behalf, they will make it, provided that your account is in funds to make it. If you lose that core principle, then you put a lot of power in the hands of the bank who you're depositing money with to say, actually, I'm not going to make this payment. I choose not to right now. I want to think about it. I want to look into it a bit more. So you have this kind of obvious duty of the bank, but almost so obvious that you forget about it, which is when you ask the bank to do something, to make a payment, provided that your account is in funds to make that payment, the bank has to make it. And you open up big series of issues if you let the bank get away with not making that payment. And then you, on the other hand, and this is the kind of the difficulty, I guess, of the Quince-of-Bel duty, is you have situations where the bank is actually on enough notice to say, well, hang on a minute, is this really a payment I should be making? And what you see going through the cases, and we can maybe pick out a couple, but this judgment probably goes through, I'd say 20 plus different cases, and I don't think we can go through all of them on this podcast. But what you see is repeatedly that the issue that the court has to consider is whether the bank was on sufficient notice that the person trying to make the person kind of acting as agent for the account holder, whether that person was doing something fraudulent, whether the instruction itself was fraudulent. And as we've said at the outset of this podcast, the difference here is that there's no issue of agency. It's very much the principle directly saying, we ignore you, we ignore your warnings, make the payment now. And in those circumstances, what duty does the bank have? Is the bank obliged to let you make the mistake, or is the bank obliged to prevent you from making the mistake? And I think it's just, if you look at it from that perspective, then in my view, the decision is the right one here, because the bank shouldn't be the arbiter of whether you're making a mistake or not.
Yeah, and I think that was the point that Justice Leggett so eloquently put. When you're looking at the duty to exercise reasonable care and skill in complying with that mandate, and you're looking at whether the bank has complied with its duties, it's very difficult to reason that the duty of care and skill carrying out the customer's instructions would ever lead to a conclusion that you should reasonably and with care and skill carry out the customer's instructions by not carrying out the customer's instructions. That's a difficulty with the way that the duty was formulated in the Quince-of-Bel case.
Yeah, I think that's right. It's an interesting point. And I think where the Supreme Court gets to in this decision is quite an interesting place, because they effectively say there's nothing special about this duty. It's not some kind of new piece of law that came in the late 80s, early 90s, and since then it's really changed the dynamic of banking. It's not that at all. It's a historic duty of a bank. It's a historic general duty of care that a bank has had to interpret the customer's instructions and act on them. But also that where the bank has put on inquiry that the instructions have not come from the customer, the bank is not required to or the bank is in fact positively required to look into the source of the instructions and make sure that those instructions are in fact from the customer.
And as a result, that it's all simply a straightforward application of agency law.
And that actually takes up, the agency. The agency piece in this decision is quite substantial. When I was reading through this judgment, which is, I think, maybe not scathing in its critique of the initial Quince-of-Bel case, but it's not far off. Some of there was a bit highlighted here where effectively what the Supreme Court says is that the problem with Quince-of-Bel duty, or the problem with the way that the Quince-of-Bel duty is framed in the Quince-of-Bel case, it kind of starts from a false premise. And the false premise is that the bank has been given an order that it has to follow, or the bank has been given an order that prima facie it has to follow. In this case, the judgment says, having perceived a conflict which does not in reality exist, Justice Steyn had no principled way in which to resolve it. That jumped out to me as quite sharp language. But the point really is, if you look at this from the perspective of some kind of new duty that you're trying to impose on the way that a bank interacts with its customers, then you're doomed to fail, because you're necessarily creating a situation that the rest of the world of law hasn't really, or the rest of the body of English law hasn't really considered the situation. Whereas if you strip it back and look at it from first principles, what's a bank's duty to its customer? What are the principles of agency? Then actually you realize that the picture is a lot clearer, but also the duty doesn't necessarily exist.
And that I think it takes us sort of to an interesting question, which is, it's evidently everyone sees the issue with APP fraud, and APP fraud is considered something that the courts want to tackle, and they do want to impose duties on the banks to try and limit, given that the bank is in such a powerful position, that it has all of the resources and it has the ability to try and prevent this fraud much better than the everyday consumer who's played up and tricked up in the fraud. It seems like the interests of justice should put that duty on the bank. But as Justice Leggett makes clear, the imposition of that duty has to have a sound judicial base. It can't proceed from this sui generis duty of the Quince-of-Bel duty as was initially posited by Justice Steyn.
Or a legislative duty, as they say at some point, as the Supreme Court often does in its decisions, particularly when it's making a decision which is perhaps unpopular with an individual. And this is true as a matter of law, but I think that there's always an interesting thing when you're reading Supreme Court judgments. I think the Supreme Court is maybe more aware than the commercial courts beneath it that their judgment might be read by for anyone with an interest in law rather than necessarily commercial parties, and often the judgments written by or handed down by the Supreme Court for that reason are very readable, very clear, and aren't shy about restating first principles. And one of the principles that they state here is, look, we can't create a legal duty that doesn't exist. We have we can implement a duty which does exist, or we can implement something which the UK Parliament, by an act of Parliament, has said exists. But we can't just create a duty out of thin air. And it's almost one of the judgments where they're kind of asking Parliament, do you want to do something here? Do you want to recognize this issue and maybe jump in and create a framework for us to be able to use in finding that banks do have this duty? Yeah, I still have some issues with that in principle as a matter of policy, that the bank would be the one that says you can't make that payment because we deem that it might be fraudulent. There is a conflict between what a bank, I suppose if the shoe's on the other foot and you're saying, no, I want you to make this payment, it's not fraudulent, I want you to go ahead and make it, and the bank is saying to you, I'm sorry, but we can't. Policy says any payment that you're making to these people, or anyone with this, the payee has this name in it, and therefore that's flagged something up on the system. It's going to take us another week to make sure your payment goes through. there are lots of situations where you go, actually, this is really irritating. I want you to make the payment that I've asked for.
And how many times have we even seen, Calum, in our cases, that the timing of the payment is critical to the party's obligation?
Really good point. If you maybe one for the shipping listeners around us, but everyone will realize how important payment of hire is. Timely payment of hire in the charge party context. If a bank steps in and says, actually, it's going to take me a week to make sure you're not doing anything fraudulent here, or you're not being defrauded, then that a lot of the world of commerce relies on banks executing payment instructions swiftly and without really questioning, save for things like sanctions and other issues where the banks are potentially liable themselves. But generally allowing the account holder to make a payment without questioning whether that payment is made fraudulently or is made pursuant to a fraud is one of the real tenets of banking practice. I think there is a difficulty with just riding over it because of fraudulent activity. I suppose the answer is in somehow stopping fraud. But I think that's a very difficult thing to do. I strongly suspect, actually, this kind of problem, this individual fraud, is going to get significantly worse by alarming factors with the rise of AI and the ability to fake voices, fake conversations, fake videos. Actually, fraud is probably going to be completely rampant, and it would be so high tech and so developed to the point where a bank would probably struggle to impose any kind of reasonable assessment on whether someone is being defrauded within a reasonably short period of time from now.
Yeah, I completely agree. And I think another point which was made really well in the judgment is the standard. One of the reasons why it should be left potentially to the legislature rather than the courts to grapple with this issue is it would seem to me that the standard is totally different for a consumer like Dr. Phillips, who's been subject to a very sophisticated fraud, than a commercial party or a shipping company, which would have its own sophisticated accounts team. They've received training, they've got guidelines and procedures and policies in place to try and prevent this fraud. Legislation can deal with that, and they can create separate classes of consumers and companies and separate the application of those principles out. But interested to see whether you agree with that, Calum, and whether you think that actually, there is a role here for the courts to try and still impose this duty on the banks, or whether really they should just stay clear and leave it to the legislature.
I think the bank should be required to make sure that the person giving the instruction has authority to give that instruction. And if the bank is on notice that the person may not have that authority, then they should be investigating whether or not that person has that authority. I think that's sensible. I think that makes sense. And I think, as the judgment makes very clear, that's in line with all principles of a bank's duties historically, but also principles of apparent authority and actual authority. I don't think that there should be a duty imposed on a bank, whether by the courts or by Parliament, to say that the bank is liable for a fraud committed on the person who then instructs the bank to make payment pursuant to the fraud. I don't think it's dealing with the problem in the right way. I think that there probably is going to be a massive problem with fraud in the next, 5 to 10 years. Probably sooner than that, given how fast everything's developing. I just think that solving the problem by penalizing a bank that pays out against the fraud would be a very difficult position. It would put a lot of payments in a very difficult position, it's hard to, and particularly on this push payment side, because this isn't a situation where the bank realizes, Calum has added a new payee to his account, and he's now trying to transfer his entire savings out of his account to that new payee. This is suspicious. Flag it, right? That's your pull payment situation where someone's kind of found a way to hack into your bank account and they're trying to pull everything out of it. This is a different one. This is where I go in and I say to the bank, hey, I want to make this transfer to Leo, and the bank doesn't investigate Leo, and I then turn around and say, oh, actually, if you had investigated him, you would have seen it was a fraud. Sure, but it's also on me to investigate before I ask for the payment to go out, and that's maybe kind of unsympathetic or prioritizing the bank over the individual. But I think these things do come full circle, and you would end up in a position where the bank would have to spend so much time investigating every payment you try to make that it would actually end up being worse for a consumer to deal with that sort of situation. There probably needs to be a lot of education around these kinds of frauds, and there already is. But I do think it's something that will probably get worse before it gets better. And I dare say that Dr. and Mrs. Phillips are not going to be the last people who are unfortunately, suckered by one of these horrible stories where they've lost all of their life savings, which is a slightly sad note to end on, really. But I think it's probably where we are with banking law. I suppose to round one thing off, we had a guest on the podcast not too long ago, Matt McGee, barrister at 20 Essex Chambers, and we were discussing a Hong Kong case that looked at the Quince care duty. I don't think, I'm open to be corrected by Matt if he's listening in on this, but I don't think that this decision would have had a huge bearing on the Hong Kong case, on the grounds that the Hong Kong case was looking at the kind of classic Quince care question of whether or not the authority was good. It was one of those authority situations rather than a kind of personal interest as we had here, or a direct instruction from the person responsible. But subject to that, Leo, I think we can park this one. We can land it.
That's great. I completely agree. It's been an interesting discussion that's thrown up a lot of curveballs in terms of how we go forward and deal with these issues. But ultimately, I think it's all going to be resolved through the legislature, and it's not going to be something that is legislative that is going to be put through and developed through a novel duty, which is precisely, as I think we've discussed, the best way to deal with this. Excellent.
Well, thank you, Leo, for coming on. I think probably normal service resume next week when Luke is back, but it was a pleasure having you on. Appreciate your time, and thank you everybody for listening. As Luke always says, please do like us or share or whatever button you're being prompted to push on your streaming platform. We do appreciate it. And if you have any questions or comments or queries, or you want us to do a particular case, always open to those kind of suggestions. So thank you everybody for listening in. Thank you, Leo, for joining us, and goodbye.